My name is Georgia Prideaux. I am a survivor of childhood domestic violence, as well as domestic violence as an adult, where my attacker pursued me for 10 years. Most of my offences occurred after I left. I had 2 sexual assaults, burns which occurred in between, which we couldn't prove, and my attacker went to jail twice as a result of offences against me. My attacker used the family law court system. He would use them while he was in jail. I would have to sit outside the jail while my daughter went in. Finally, I got a lifelong restraining order in 1999. They decided enough was enough. We rallied to make that legislation so other victims of crime and domestic violence situations can also access lifelong restraining orders, which is now in place here in West Australia. Also, we made it, when you committed an offence in front of a child, it's considered aggravated, therefore it's a criminal offence, so we've criminalised certain assaults in domestic violence, so we have managed to come a long way in that regard.
My name's Angela Hartwig and I'm the Executive Officer for the Women's Council for Domestic and Family Violence Services in Western Australia. It's not uncommon for violent perpetrators to apply to the family law court for contact and residency of their children. It's a well-known tactic in domestic violence. What we see here in WA, which is very disturbing, is that violence restraining orders are overridden by a family court order. So often police will go to a refuge and remove children and put them in the hands of a violent perpetrator. This is outrageous and it needs to stop. It's very traumatic for the children, for the mother, and for the refuge. And it says nothing for the safe haven that the women and children are in. So one would question, if a woman and children are in a refuge, why are they being removed and put in the hands of a violent perpetrator who has access to weapons, a history of violence? It's not rocket science to work out that that's a very unsafe practice, and we'd like that changed immediately.
Hello, my name is Kerry Davies and I work for the Council of Single Mothers and Their Children, and we hear daily from mothers who are concerned for their children's safety after court-ordered access. In one case, custody was granted to the father because of the mother's homelessness. She was homeless because it was the only way to escape his violence. Now their 16-year-old daughter is being bashed regularly by her father and calling on her mother for help. In another case, we have something that is no accident waiting to happen. One mother was concerned about supervised access being granted. Both the children and herself were victims of extreme violence, and the perpetrator owns 7 guns. She has been made responsible for providing and enforcing the supervision during his access visits with the children. It is clear that the courts should have done more to protect this family.
Hi, my name's Jackie and I work at Childwise. I run the National Child Sexual Abuse Helpline. We know through research and experience that most children are sexually abused by someone they know and trust. Children can't fake the trauma effects of child sexual abuse. It's up to adults to notice, believe and protect them. No parent wants to believe that their child has been sexually violated. As a parent, imagine how that would feel. I hear the desperation in the voices of the parents that call us at Childwise. They believe their children, and they also believe that due to family court orders, their child is in contact with someone who's continuing to hurt them in this way. We must listen to children, educate our courts and ourselves, and make this stop. Thank you.
My name's Robin Purvis. I have extensive experience working in family law as a counsellor, evaluator and mediator over 28 years. I share with many a deep concern about the family court's failure to protect children in many instances. The challenge is to understand why, despite the good intentions, the training, education, new initiatives developed by the court, that the court continues to fail in its mandate to provide for the best interest of children in many cases. There are a number of factors I think contribute that we need to consider. The adversarial process in this context has limitations. Abuse and violence within relationships and families are soft evidence issues and are difficult to determine. and this is in a context of a very limited understanding of the dynamics of abuse in society and among the professionals who work in the family law area. There is an unacknowledged bias. We are more concerned about the rights of the accused rather than the protection of children. We need to move to a place where we can err on the side of the protection of children when in doubt. As a society, we have an innate identification with the perpetrator and limited ability to identify the victim. We deny our own vulnerability and unconsciously blame victims. We're angry at women for not protecting their children. This is easier than challenging the behaviour of the perpetrator. We need to understand why. It is these structural and unconscious influences that impede us as a society from protecting our children.
I'm Dr. Amanda Shea Hart. I'm an experienced dispute resolution practitioner, academic and researcher. Parenting disputes where domestic violence is an issue is core business of the family courts. Decisions that are truly in children's best interests must be based on specialised assessments that thoroughly investigate the impact of violence on the child and on the adult victims and actually identify any future risks. A failure to do this means that courts rely on dominant assumptions about alienating mothers, about violent husbands being loving fathers, and about children needing relationships with both parents. When this happens, this can place children at ongoing risk.
I'm Mari Hume from the National Abuse Free Contact Campaign. More women and children are killed at the time of separation than at any other time. In fact, post-separation is the most dangerous time for women and children who are trying to escape from domestic violence and child abuse. And yet the family law system places the interests of abusive men over the safety of women and children. We see this all the time. This must change. Make family law safe for women and children.
I'm the manager of Women and Children's Refuge for women and children who are escaping domestic violence, and I continually see decisions made by the family court where basically children are offered up like property for contact purposes, where domestic violence has been proven and in fact there are apprehended violence orders in place. Often children have witnessed the most extreme and horrendous violence, and nevertheless a family court judge will naively pick up this default position around a child having an entitlement to a relationship with both parents as if it sits in isolation of that experience of the violence. I see it as being very naive, and I also see it as being a game of Russian roulette that we're playing with these children's lives. And there is capacity in the Family Law Act as it stands just now for judges to make a decision that because of the violence it is inappropriate for contact to occur. But I believe that there needs to be further legislative change which is around a rebuttable presumption that where there is domestic violence, contact will not be allowed until the parent can show why they're entitled to have it.
I'm a researcher at the University of Sydney, and I do research with women who are trying to deal with domestic violence in their lives. As a society, we're very quick to judge women who don't leave a domestic violence situation. We often ask, why didn't she just leave? Why did she continue to expose her children to that terrible violence and abuse? However, my research shows that when women do leave a domestic violence relationship and try to establish a safer life for themselves and their children, they are often met with disbelief. This attitude of disbelief permeates the family law system, the child protection system and contact services, leaving many women unsupported in their efforts to protect themselves and their children from exposure to domestic violence. My research has found that the current family law system, with its emphasis on shared parenting, is leaving many women and children unprotected. Our current system of family law is failing to protect children from continually being exposed to the trauma of domestic violence.
My name's Hazel. I work at a refuge for women and children who are escaping domestic violence. These women and children may not be abused physically, but they are abused emotionally and financially and isolated from family and friends. So they're very, very traumatized when they come into the refuge. Now, that some of the children are very afraid of their father or the partner or the ex-partner, whoever the perpetrator is. So we get protection orders for them. Now, this is a bit contradictory, as when they go to the family law court, it's overruled, and the perpetrator is then deemed as a good parent. It's very frustrating for the mothers and for us as workers. You get very angry, and sometimes it's a very long process.